watching the Florida Channel, a public service of the Florida Legislature. You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case for the day is the reprimand of Judge Dale C. Cohen. Judge Cohen, please step forward. Good morning. Judge Cohen, we've summoned you here today because of conduct which this court has determined to be in violation of the Florida Code of Judicial Conduct, and which now requires us to impose appropriate discipline. As the Code of Judicial Conduct recognizes, judges individually and collectively must respect and honor the judicial office as a public trust and strive to enhance and maintain confidence in our legal system. The effectiveness of our judiciary rests ultimately on the trust and confidence that the people confer upon judges. As a result, one of this court's most important duties is to carry out the responsibility given to us in the Florida Constitution to discipline judges for misconduct. Judge Cohen, in August 2009, an attorney appearing before you filed a motion to disqualify you in a case because of an alleged conflict of interest. Specifically, the attorney had supported your wife's opponent in a judicial election for another circuit court seat. According to the motion, the attorney and your wife became involved in disputes over his work on behalf of your wife's opponent. Under the rules of court, you were required either to grant the motion for disqualification or to deny it as legally insufficient. Instead, after having lunch with your wife, you brought your wife into the courtroom, called her to the witness stand over counsel's objections, and questioned her about the facts alleged in the recusal motion. In doing so, you forced the attorney to place his own credibility against the credibility of your wife. You acknowledge in your testimony that these actions violated the Florida Code of Judicial Conduct in allowing your wife to testify and in not following the law. This was a violation of Canon 2A of the Code, which requires judges to respect and comply with the law. Likewise, you allowed your judicial conduct to be influenced by social or family relationships in violation of Canon 2B. Your conversations with your wife about this matter also constituted ex parte communications, which are forbidden by Canon 3B7. At the same time, you presided over these proceedings, despite the fact that disqualification was required, thereby violating Canon 3B1 and 3E, which require recusal if a judge's impartiality might reasonably be questioned. The conduct at issue here violated Canon 3B2, which requires judges to remain faithful to the law. Further, your actions establish a violation of Canon 1 and its commentary, which forbids behavior that undermines the integrity and independence of the judiciary. And an observer of the hearing at which your wife testified certainly could have reached the conclusion that you were using the power of your office to vindicate your wife against accusations by an attorney who had supported one of her opponents in her election campaign. The hostile atmosphere you created was only exacerbated in later proceedings when you showed similar animus toward the same attorney. In its recommendations to this court, the JQC suggested that the appropriate discipline is the public reprimand you now are receiving and repayment of the cost of the proceedings. We agreed with the JQC in our opinion issued on August 30th earlier this year. Judge Cohen, the Supreme Court of Florida hereby publicly reprimands you for your misconduct and orders you to pay costs as provided in that opinion. Finally, I advise you to consult the lengthy body of case law issued by this court in dealing with cases of judicial misconduct. You will find that this court has viewed any further violations by a judge very harshly indeed. You're free to leave. The next case on our docket is Daniels versus State of Florida.
Good morning. My name is Bruce Taylor, and I am representing the petitioner, Aaron Daniels. I may take a brief moment to thank the court for continuing these arguments from last month when I was ill. Appreciate that. The issue before the court today is a succinct one. Did the 2008 amendments to the standard jury instructions on the charge of manslaughter cure the problem that this court recognized existed with the pre-2008 instructions in Montgomery? It is our position that the additional language in the 2008 instruction did not cure that problem, and that fundamental errors still existed with the giving of that instruction. Let
me ask you a question before you go further.
Sure.
He was initially charged with first-degree murder?
He was indeed.
And he was convicted of second-degree
yes.
murder. And the second-degree murder instruction was an instruction that talked about not having any specific intent to kill.
Correct.
So he was convicted under that. Correct.
As I understand it, the issue is, and And once again, jurors are obviously lay people, and they may not understand the nuances between what's a lesser and what's a more serious offense. And they're looking at, in Mr. Daniels' case, 3 possible charges.
I guess my question really is, does the conviction for second-degree murder then lead us to the conclusion that the jury was concerned about whether or not there was an intent to cause the death?
Absolutely. Obviously, they felt that there was no premeditation to cause the death. And, of course, premeditation is intent that's held for a period of appreciable time.
Yeah, but my understanding of the facts, application, residence.
Yes.
And then away, went home, got a gun, came back, and shot at someone and hit an unintended person right in the head and killed her. I mean, why does that not fit perfectly into the second-degree murder instruction of the depraved mind and so on and on? Why is that not a second-degree murder case?
Well, I'm not saying it's not. The issue before this court isn't whether there is sufficient evidence to sustain the verdict that was returned. Quite frankly, a jury, probably under those facts, could have also convicted him of first-degree murder. The question is, and this was sort of what I was getting to.
Well, typically when you have an altercation and you have this loss of temper and so on and on, it's typically a second-degree murder case.
Right.
And that's what you had. You had a fight.
I said it could be.
Right.
If a jury had come back with first-degree murder, I would be hard-pressed to say that the facts didn't support that. But here's where I think the issue is. Although the facts may have supported a verdict of second-degree murder, the problem with the defective jury instruction on manslaughter is, like I said, we have lay people on the jury, and they're debating. Yeah, but presumably if they're talking about what to convict him of, they're not thinking about a not guilty. So they're thinking about manslaughter, second-degree murder, and first-degree murder. Right. And they are told in this instruction that 2 of those have intent. The first-degree murder clearly has intent. In fact, it requires more than intent. It requires premeditation. They were also told that the manslaughter requires intent. In fact, that's the flat-out, unambiguous language. One of the elements of manslaughter, as they were told, is intent to kill. Now, we all know that that's not one of the elements of manslaughter.
So, but then later on in the instruction, they are told that it is not, the intent is not premeditated, and it's simply the intent to commit the act that leads into. So, my question is this: if a jury is told that it's not premeditated intent, what other intent is there other than intending to have done the act itself?
They were instructed extensively on what constitutes premeditation when they got the first-degree murder charge instruction. And there is a difference between, I'll call it simple intent and premeditated intent. And the additional language is addressing the issue of premeditation in manslaughter. I mean, it starts out, in fact, that instruction says, as was given, says, in order to convict of manslaughter by intentional act, it is not necessary for the state to prove that the defendant had a premeditated intent to cause death, only an intent to commit an act which caused death.
Well, what would that, doesn't that mean to a layperson that it's the intent to shoot that is part of manslaughter by act? And I guess my question with that is that, certainly I will, as part of the court that approved that instruction, an experienced defense lawyer presumably didn't see that there was something misleading about this instruction. It had been done to correct what had been there in 2006, and what was the defense lawyer's defense to this? Was the defense lawyer asking for a not guilty? Were they asking for a manslaughter? I mean, what was their argument to the jury?
Based on his argument, I was thinking, I would guess, that he was hoping for a manslaughter.
Okay, and so what did he argue to the jury? Did he say, did the state say you have to prove an intent to kill for manslaughter, and there was, or did they argue it as we're now seeing would be the common understanding, which is an intent to shoot?
Well, as described in the district court's opinion, defense counsel did in fact go through, and I thought made a pretty good summary of what manslaughter would be under those circumstances. However, I don't think
And did the state say no? They're not correct.
No, I don't think so.
Okay.
Well, let me. Can I make a comment about it? You can't look at defense counsel's argument to cure a flaw in the instruction.
Well, if we're talking about fundamental error, because there was no objection that it goes to the validity of the conviction, we can sure talk about how it would have possibly affected the verdict, where you're saying, well, the jury must have thought that manslaughter meant an intent to kill when nobody argued it that way. Well, no, they weren't. That's why I go back to what Justice Quinn says. They were told that it was only an intent to commit an act which caused death.
The problem with the instruction as given is that they start out by saying there are two elements.
I agree. Listen, we have, going forward, there's no question, with the assistance of some of the Justice Labarga and others, that we hopefully now have an instruction that is absolutely correct. The question is, was this so incorrect as to constitute fundamental error?
Well,
isn't that? I mean, that's what's
that's the bottom line.
All right. And so, do you think for that fundamental error analysis, do you look at all at the facts of the case?
Well, if it's fundamental error indeed, I don't think the facts of the case come into it.
Well, of course it does, because it's a question of whether it affects the validity of the verdict. I mean, it's a question of whether the jury was misled as to what the crime of manslaughter by act was.
But we can't tell what the jury thought,
well, we
because
can tell
they were
based
given
on
contradictory instructions.
That no lawyer in the courtroom thought was contradictory, and the lawyer using this instruction argued it correctly.
Apparently
correct?
No lawyer thought it was a problem with Montgomery either, and that was still found to be.
Let me just, my concern, and perhaps this is favorable to you, is if you look at the charge that the jury heard, elements: 1, Amanda Lynn Ponter is dead, and 2, Aaron Travis Daniels intentionally caused the death of Amanda Lynn Ponter. Okay, those are the two elements required of manslaughter. So the second element that I talked about, intentionally caused the death of the victim in this case, is what we're talking about here. Then you go down to instruction, and it says that you don't have to prove that he had a premeditated intent to cause her death, but only to have the intent to do the act that led to her death. So we're dealing with, an element of the crime of manslaughter, and that's where I think your best shot of fundamental error is placed, because it is confusing to the jury, I would think, as to what the law is. I mean, do we find that he had to intent to kill her, or do we find that he only intended to fire the gun at a crowd of people?
Well, my thought, for what it's worth, is that the new language at best creates a contradiction for the jury to sort out. They are, at one point, they are told unambiguously, he has to have the intent to kill.
No, it says, it says, and maybe it says intentionally cause the death. Now, the question is that different than an intent to kill? And therefore, it's clarified in the end. Now, I can see both sides, so I'm not like here going, I'm sure that you're right or wrong. I think we really did not do a favor to trial judges, and again, I'm part of it, so that we may have had confusing instructions. The question is whether that confusing instruction, as opposed to being absolutely a defective instruction, constitutes fundamental error, and that's where I'm not sure this is as clear as the Montgomery instruction.
Well, here's what I started to say a long time ago, why I think the new language didn't really do the trick. First of all, in that one place, you say the language, I won't paraphrase it, is that Aaron Treves Daniels intentionally caused the death of Amanda Lynn Fanter. That, to me, sounds clear and unambiguous. You know, if we were interpreting statutory language here, we would say that's the plain language of the statute. It's not for the court to further interpret that. I'm thinking the jury would think the same thing. They've heard the judge say you had to have the intent to kill her.
I guess my concern is that this instruction was, and I have to go back to how this particular one came about. I don't recall, and you may tell me, did the public defender say you haven't cured the problem from 2006?
I don't know.
Nobody. Not a peep out of anybody. And now we're going and saying we now have to reverse all these convictions because of something that now, in hindsight, isn't as clear as we may have wanted it. And that to me is, I'm concerned. I mean, whether this man got a fundamentally unfair trial, or he was fortunate to escape with second-degree murder as opposed to first-degree murder.
Well, I think we've all seen factual situations that, sometimes the juries reach surprising verdicts. I don't think that's really what we're talking about here. We could say, oh, this guy perhaps was lucky to get second-degree murder under these circumstances, but whatever, he is entitled to have the jury decide all three offenses being properly, and I would say properly means clearly instructed on what the law. As given at best, at very best, the jury is faced with the judge saying at one point there has to be the intent to cause the death, and at another point he's not saying that. And are we saying that is not fundamental error to have the jury sort out those two things and reach a correct decision?
Is there a difference between an incorrect jury instruction and a confusing jury instruction? Because it seems to me that what we have is not necessarily incorrect, but confusing. Because on the one hand, you do have the statement of intentionally caused the death, and then you have the later statement, which I assume was intended to clear that statement of only intended to commit the act that caused the death. So is that an explanation of what intentionally caused the death is?
Well, I would just refer to this court's own opinion in Montgomery. The only language that was added was it's only necessary to prove the intent to commit the act that
but that
caused
was a
it.
pretty
But
significant
the language
thing.
about the premeditation was in there even under Montgomery.
But if you look at the defense lawyer's closing argument, it specifically says they don't have to prove malice, they don't have to prove premeditation, they don't have to prove any of that. What they have to prove is that he intended to do the act which caused the death, that is the pulling of the trigger. And that wasn't objected to by the defendant, by the state, as being an incorrect statement of the law. And nobody said, but this instruction doesn't do it.
However, the jury is repeatedly told, you get the law from the judge. Don't get the law from the closing arguments. So that's one of the reasons I said earlier, you can't use defense counsel's closing argument to sort of fill in the gaps or more adequately explain.
Yeah, counsel, I'm having trouble understanding how a rational jury, based on the facts here, could decide that this was. It just doesn't. The facts here don't seem to fit that crime. because, as I understand it, the defendant was involved in some kind of confrontation. Then he left and got a gun and came back and shot into a crowd. And he said himself that he didn't mean to kill anybody, but he probably meant to hit one of the men. Now, that just doesn't quite... Tell me why that could be a manslaughter by act as opposed to a second-degree murder that requires a depraved mind.
Well,
it seems like there's a depraved mind operative here.
Well,
beyond dispute.
Different people can reach different conclusions.
Well, I understand that, but tell me about a rational juror.
Are you asking me how I would vote if I was on that jury? I'm not going to answer that question because I wasn't on that jury. But I will say this, if you can permit me to tell a war story. We have all seen cases that surprise us. Rational people come in and make and the one I'm going to think of came out of Pinellas County, and it arose when I was the general counsel for the school board. And we had two young men who were suspended from school. They decided they wanted to go back onto the school grounds. They came back armed, and when an assistant principal grabbed one of them to make him leave the campus, a struggle ensued, and the other young man shot and killed that assistant principal. And he also shot another one and seriously wounded her and wounded a teacher as well. And the jury came back with manslaughter. I was very surprised at that verdict. But that's what 6 people listening to the facts of the case, and it may have been 12. I don't know if he was charged with first-degree murder. I can't remember that much of it. But the point is, you can disagree with a verdict, but the point is, it's the public, the members of the jury, that listen to the facts and they decide in their own consciences whether they have a reasonable doubt as to each and every element of the offense. And yes, under the facts of this case, I do see where at least a reasonable jury could say that's not quite second-degree murder, it's more like manslaughter. Not every jury would say that. Maybe most juries wouldn't say that. But, we can't sit here and be a jury. This case should not be decided on whether or not we would agree with such a verdict.
You're deep into your rebuttal time.
Then I'm going to sit down.
May it please the court, counsel, my name is Sarah Max and I represent the state. Justice Quince brought up a good point about, is there a difference between an error or a fundamentally erroneous instruction or one that just causes confusion? I think that's a really good point, because in Montgomery, part of the problem was that the 2008 instruction, it informed the jury or it did not inform the jury of what intent was. It said premeditated intent as a contrast, but it didn't say what it actually was. In this case, the 2008 instruction actually provides a definition of intent. All of a sudden, the jury got this aha moment. We have this word intent, and now we have a definition of it. It is the intent to commit an act. Now they have something to...
Let me ask you this. I mean, the instruction reads that the defendant intentionally caused the death of the victim. Do you agree that that is an incorrect statement of the law on manslaughter? Intentionally caused the death of the victim. That statement alone?
No, that is not the correct. That's in line 2A. That is not correct. The state does not agree that that's correct.
Well, you got a bunch of double negatives there. Which one do you agree with?
We line 2A. The state does.
You agree that that's incorrect.
That's incorrect.
Okay, all right. So do we have an incorrect instruction, not a confusing one?
A confusing instruction, because we agree that line 2A, or that the definition of intent is in fact correct, and we believe that cures the error in line 2A. Why? The same reason that Judge Black wrote in the opinion from the second DCA. Because now they have that definition of what intent is supposed to be. The jury reads the instruction as a whole. They don't just read line 2A. They read the whole instruction the same way.
Wouldn't it have been better placed, that if this is going to clarify 2A, that you would have put that. We should have put that.
Yeah, but you're part of this.
I wasn't here at the time.
That right there behind 2A. If we were intending to define what intentionally caused the death is by what we have later, shouldn't it have been right there? Because it's separated by this other thing that it's usable or justifiable. It's not manslaughter. So we're expecting now the juries to, do they?
Yes.
Basically, I assume recollection, but so we have this separated, and I'm not sure that it really does cure what we thought we were curing by putting it after the excusable and justifiable.
I do understand where you're going, and I think in a best practice world, absolutely. That's why we have jury instruction committees, to go and review the instructions and say, hey, you know what? We actually do need to change line 2A and correct it. And in fact, now we have the 2012 instruction, and it has that language. But it goes back to what Justice Pariente says. Does it mean this jury instruction is actually fundamentally erroneous? And that's when we can say, no, it's not fundamentally erroneous because it has this saving language. And we can apply it to the facts in this case. Because when you do a fundamental error analysis, you do have to apply it to the facts in this case. You do have to look at everything that did happen.
But you agree, and I understand what Justice Kennedy said, but that although second-degree murder may fit best in what happened here, that there was certainly a basis, as the defense lawyer argued, for manslaughter by act.
Absolutely. But second-degree murder is a better
What's the factual basis for manslaughter by act?
The factual basis for manslaughter by act would be that it's a stretch in this case, absolutely. But the factual basis would be that the defense, because he shot into the crowd. This woman was part of the crowd, so it's kind of that factual scenario, which if the jury believed that he shot in the crowd, the problem is that he came back with the gun. So and didn't
he say that he probably meant to hit somebody?
Somebody. That's the problem with that. So I think
why wasn't that intent? I still don't understand why that's the factual basis for manslaughter by act.
Well, if the jury believed that, the state does not believe that. The state truly believes that, they charged premeditated. So the state truly believes he had the premeditation because he went out and he came back with the gun. But the manslaughter by act, why they could possibly come back with manslaughter by act would be because he shot into the crowd. So if they did not believe that thought of that he really wanted to hurt somebody and hit somebody, and he just shot into the crowd, that would be the manslaughter by act factual scenario in the facts we have. The second-degree murder is he really wanted to hurt somebody.
What I have trouble understanding is how shooting into a crowd could not be seen as anything
shooting
other
into a
than
crowd
evidencing.
I was going to say, that's actually going to be a second degree.
Let me finish?
Sorry, I apologize.
How that could be understood as anything other than an act that evidences a depraved mind regardless of human life.
I would agree with that. You're right.
Well, that's not what you've said.
I apologize.
Well, you're here to make the argument for the state.
No, the manslaughter by act is a stretch. Manslaughter by act is a stretch. I'm trying to come up with a factual situation.
Manslaughter by act is you have a person that's dead, this victim is dead, and the other part is that you did an act that you intentionally did an act that caused the death. If you intentionally do the shooting, while this may perfectly fit into second-degree murder, it seems to me that you still have the elements of manslaughter by act here also.
Right. The defense
a death and an intentional act.
The defense attorney argued the pulling of the trigger. The problem in this case is that he did shoot into the crowd, and the problem in this case is that he did say that he intended to harm somebody when he came back.
Well,
so those are two facts that it's hard to get around for having an actual manslaughter by act conviction.
But the facts of this case satisfy every element of manslaughter by act, does it not?
Yes, if you'd have to believe certain things.
Even if you're talking about going beyond those elements are satisfied, correct?
Yes and no. I mean, it's hard because the facts of the case don't weigh so heavily against a manslaughter by act.
Well, counsel's argument is that because the instruction is so conflicting that it legally, technically, and basically deprived the jury of reaching the conclusion of manslaughter. And I bet that if I was to go into Westlaw when I get back to my office and put in drive-by shooting, manslaughter, and where a couple of guys went by in a car and stuck a body halfway out the car and started shooting at a crowd of people, and some little girl got killed who just happened to be standing in the corner, I bet I can find a number of manslaughter convictions for the hundreds of drive-by shootings. And that's really not much different in this. And what he's saying is that in a trial, anything is possible. It is likely they would have come back with second-degree murder anyway, but by virtue of this instruction, it's so conflicting that the juries tend to follow the law. They could not follow this law and find him guilty of manslaughter.
The state doesn't agree with that, and that's because of the saving language. You have to look at the instruction as a whole, because that saving language does provide the correct intent element of manslaughter. So the jury knew that the intent was the intent to commit an act which caused death. The jury understood that because that language was there. Nowhere in the instruction does it say an intent to kill. And they specifically also knew that it was different than the premeditated intent because that's what it says. So there wasn't that concern that they were going to go back up to first-degree murder and think that manslaughter was the same as first-degree murder. Manslaughter is that residual offense. And the defense attorney did help explain that. Although defense, they're told not to follow the law, that follow what the defense attorney is explaining the law is, the defense attorney does help explain the instructions and help explain all that stuff, and he did actually quite an excellent job of explaining what manslaughter was to the jury.
Does in a fundamental error analysis, one of the facts are important as to whether there could be any basis in the world for finding it. Does what the defense lawyer argues, although it's not evidence, does that figure at all in I think you've been quite candid in explaining your views, but does the closing argument make any difference? I mean, for me, it certainly would not be helpful to the state if this attorney misunderstood what the instruction was. So does it play any part?
Absolutely. Every part of the trial and every part of
but would you have a
facts.
case that says that? I mean, other than it seems logical, are there any cases that when they're discussing fundamental error in jury instructions, because we have, if it misstates an essential element, then that's fundamental error. Now, here, what we're saying is if it stayed just with, as you said, 2A, it would misstate it. Does the explanation save it, at least from being a complete reversal in every case where this jury instruction is given? So the question is, any of those cases that talk about how the lawyers argued the case in addition to the facts,
Of the new 2008 jury instruction cases?
No, of cases that talk about fundamental error in jury instructions.
The fundamental error the fundamental error cases in general, what they do discuss is that you have to look at the whole case itself. So it's a totality of the circumstances. They talk about how you have to look at all of the facts, how you have to analyze the whole case. I don't know of specifically a case that talks about closing argument or that specifically talks about that element itself and how that influences the fundamental error analysis. But what they do specifically look at is, or that they do talk about, Garzone and all those cases talk about that you have to look at everything that goes into the case itself when you're analyzing fundamental error. That's the important, which to me would include the closing argument, because that is part of the case in its totality. One of the things that is particularly decisive about this case that I think contrasts it with Montgomery is the fact that because that added language is in the jury instruction, and that really, I think, highlights the difference between these two cases. Why is this case different from Montgomery? And this addition to the jury instruction kind of contrasts with the Montgomery jury instruction. So now we have a manslaughter jury instruction where they don't have to look up. They can use this as another option for.
Let me ask you this. Does it come into play here at all that he was actually convicted of second-degree murder? So the next offense that's one step removed from the second-degree murder is the manslaughter, correct?
Right.
And so, we have a legion of cases that talk about having a correct instruction for a offense that is one step removed from the offense that he was actually convicted of. And so how does that play into the analysis of whether or not this was, in fact, a correct instruction to the jury?
The concern that was in Montgomery and the concern that would still be in this case is that instruction needs to go through fundamental error analysis, whether or not that instruction is fundamentally erroneous. And so the concern then becomes whether or not that instruction, can the jury look at that instruction, and can the jury actually see whether or not that instruction allows, in this case, an intent to commit an act which caused death? Do they understand what that really means? And if they don't, was it so fundamentally erroneous to vitiate the whole case? So the state would argue that the instruction was not erroneous, that they were able to actually look at the instruction, understand what the intent was, and use that as a proper lesser, and that this was not a case of fundamental error because of all the facts and everything of this case itself, and that allowed them to
what degree offense is manslaughter by act?
Manslaughter by act is I believe it's a second degree.
And what is second degree murder?
First degree. And first degree is a capital.
Let me ask you about the facts. How far in distance was the victim from the group of men that he said he was shooting at?
I can't give you an exact yardage, but she was behind. There was the group that was fighting, and then she was behind them in the original scuffle. What happened then was the defendant left, got the gun, and came back. And then what happened was that the guys that were fighting had scattered. She was actually around the side of the building from where the original scuffle happened. He came back and kind of shot into where that group originally was. The eyewitnesses and everything
how many men were in that? Were they standing there?
They were all kind of still around at various places. Some were at cars, some were back at the apartment where she had been standing originally. So they were kind of all around at various places.
How far apart? Earlier in your argument, you discussed that he was
shooting into a crowd
of people. So if you've got a lot of people in a very tight group of people, that's one thing. But if it's a stray bullet where he was aiming at somebody else, it's a different characterization. So I'm trying to get a mental picture of what this looked like. It
was not. They were at that point. They had been scattered out more among because he came back unexpectedly. They did not expect him to come back.
Were they all 20 yards apart, or?
You know, that kind of testimony was
how far, let me go back to my original question. How far geographically was the victim from the guy that he said he was actually shooting at? Don't know.
I don't know. I don't know that type of testimony ever came out. It was because she was found near some vehicles, like that, where her actual body was found near some vehicles, and the actual eyewitness testimony came from people in different locations. And the person the one victim that said he thought he was the one that got shot at didn't actually see her get shot. So it's kind of hard to tell where they were compared to each other. I don't know that we have a good grasp on that particular question.
Okay.
The other thing I think that is really important to remember in this case is that the jury also received the first-degree murder and the second-degree murder instructions. So they had already received the first-degree murder instruction, which had the premeditated intent instruction in it. And then they had the second-degree murder instruction, which has the depraved mind intent instruction. And then they received this instruction, which has the intent to commit an act which caused death, which contrasted with the premeditated intent instruction. So the jurors are receiving 3 different intent instructions. And on the third instruction here with the manslaughter, they received the contrasting instruction with the premeditated intent instruction. So I think the jurors are receiving this information on the premeditated intent instruction versus the intent to commit an act. And that provides them with this contrasting instruction on premeditated intent and kind of puts these 3 different types of murder in context for them. Now,
were there any questions by the jury after deliberation started on the instruction on manslaughter? Did they come back with a note to the judge saying, can you please explain this, explain that on the record? I mean, we can always look it up.
I've had so many of these cases. They've been blurring together. I don't think so in this case.
Any indication that the jury was confused? A note
I don't believe in this case there was. I'm not 100% on that one, but I don't think there was any juror question in this case. I have about 30 seconds left, so we would ask this court to affirm the second DCA's opinion in this case. Thank you very much.
Thank you.
Very briefly, to answer your last question, I just looked in the transcript. There do not appear to be any jury questions. I will leave you with 2 quick thoughts. First of all, as opposing counsel just stated, the jury had been instructed on what premeditation was and then what the intent requirements for second-degree murder were. Look very carefully at the written instructions that the jurors were given to take back with them. The new language in the 2008 instructions is modifying the statement that it is not necessary for the state to prove the defendant had a premeditated intent to cause death. Only then do they, that's part of that sentence. So that sentence, that whole new language is part of a sentence that's talking about premeditation, which you already know is not applicable.
Do you know the answer as to how far the victim was?
I do not.
But it seems to me, again, what that point is that they want to believe there was a premeditated intent, they do that. If they don't think there was any intent, they do, but it's reckless, they do second. Okay, go ahead.
Yeah, I just want to say, look to your own language in Montgomery about confusing instructions, and ask yourselves if that is not still the case here. You want me to answer that question?
No,
okay.
That was okay. Thank you.
Thank you for your arguments. The court will now take a 10-minute recess.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
Our next case on the docket is Ricardo versus Brown.
Thank you, Your Honor. May it please the court. My name is Talbot Dallenberg. I'm here with Danny Kepner, and we're representing the petitioners in the next two cases on the docket. Both of these cases relate to leasehold interest of county property on one island, Santa Rosa Island, in two counties, and three different ways of taxation of the leasehold interest. And our principal point in this...
Now, so what are those three different ways?
Your Honor, in the Ricardo case, both the land and the improvements are being taxed. In the Areola case coming up next, there is only the improvements are being taxed. And the third way is that there are a group of leaseholders who were involved in the Bell versus Bryant litigation.
And the third way is your chosen way.
Exactly.
The intangible property way, property tax way.
Exactly, Your Honor. The third way is the way that complies with the statute. And
that's why we're here, right?
Yeah, exactly.
Has somebody actually taxed as intangible property tax? Has some governmental official taken the position that agrees with you? Because I thought you said it was being taxed in three ways.
Your Honor, property appraisers and courts all over this state have taken positions that are consistent with the position we urge on the court today.
So there are situations all over the state where there are the lease of the property and then somebody actually, again, these are condos or beachfront residences that we're talking about?
But, Your Honor, we're talking about...
Is that what I just want, because when we talk about improvements, give me a picture. They're condo units and they're residences?
Your Honor, I cannot identify another condo unit. I can identify for you multiple instances. I'm sorry, I can't identify a condo unit for you. It's a condo at an airport in Boca Raton.
No, I'm asking up here. Are we talking about this is unimproved land where there were condo apartments built and sold to people who reside in them or rent them out?
That's right, Your Honor. And
there are residences also built on property that is owned by the county.
That's correct, Your Honor. And
okay, under these, are they any of them shorter than a 99-year lease?
Your Honor, there are 8 parcels involved in the litigation in a companion case.
Is that 8 in this particular case, or
no,
are we talking?
No,
how many are in this case?
There are none in this case, Your Honor. And my statement, and I'm pleased to have Justice Kennedy interrupt me. My statement was there are 3 different ways of taxing leasehold interest on Santa Rosa Island, and the third is the way that's consistent with Bell versus Bryant. And Bell versus Bryant applied the 1980 statute, and that stayed in place for some period of time until Ward versus Brown was decided by the first DCA. So our central point today, the core point that we want to make, is that the legislature had authority to determine and had classified state property or the property of state subdivisions in a way that the legislature decides is appropriate. There can be really no doubt, at least in my mind, about a clear application of the statute itself. We're dealing here with clients who have leasehold interest in county property for less than 100 years.
Let me see. Your basic argument is that all of the property involved in this case, these leasehold properties, should only get They should not have ad valorem taxes, none of them. Is that
that's
okay?
correct. It should be
And
taxed
you
as
should
intangible.
only have intangible property tax.
That's correct, Your Honor.
For all of these, okay.
That's correct, Your Honor. Now, Your Honor,
Let me in connection, as a follow-up to that question, let me ask this. Do you make an argument here that would allow us to distinguish between certain categories of properties depending on the terms of the leases? That is, for instance, an argument that would say, well, if some of these do have perpetually renewable leases, those would fall in a category that's different from those that do not have perpetually renewable leases. You're not making an argument like that, or are you?
Your Honor, I think that is a perfectly principled resolution of these matters. You don't reach the taxation of land through that process, but there is some language in the statutes that says that if the improvements are actually owned by the leaseholder, then ad valorem taxes may be applied. Our submission is that the improvements are not owned by leaseholders, but where there's perpetual lease terms, that is automatic renewal for periods of time, as in Ward versus Brown, we think that those leases should be separated out. Part of the problem with all
of it. What about lease terms? There's some confusion in my own mind about the reference to automatically renewable. If that means it's just going to, I'm not sure exactly what that means, but it seems to me that you've got a perpetually renewable lease if at the end of every 99-year period or shortly before that, the leaseholder can say, I want to renew. I don't see that that's any different than a lease that would say it will renew automatically unless the leaseholder says, I don't want to renew.
But there may not be large differences, Your Honor. There is a case which we've cited, case by this court, Cisco case, which holds that leases may not be renewed for more than one term. It's against public policy in Florida for leases to be renewed over and over and over again.
Mr. Dallenberg, is there a concept in the statute of equitable ownership, or do you argue that this is a strict statutory construction case and that the legislature did not intend that in a situation like this that there could be such a notion as equitable ownership?
That's correct, Your Honor. The legislature drew the lines. It looked at the so-called bundles of rights and decided where to draw the line. The line was if a lease of government property, county property, was for less than 100 years, and if you paid rent, it was going to be taxed solely as intangible property.
Now, on the rent part, I just want to, again, and I realize maybe the facts shouldn't matter, but they matter to me. How much do each of the owners of the condos and residences, what is the yearly lease rental payment to the county?
Your Honor, assuming that you do not affirm the court below, they will pay the intangible tax rate, which is $2 million.
What do they pay to the county for their lease?
Your Honor, different terms for different leases.
Well, is it $200 or $300? I mean, it's
some as low as that, Your Honor, but others greater. All the leases are a part of the record, and they're all over the lot. Also,
and what is the difference in the ad valorem tax rate for the? I mean, and these are dollars that go to the county for improvements for roads and other types of. Is that what that goes to?
Your Honor, the county sets that rate, that rental rate, at whatever it decides to do, and spends it in whatever way it decides to spend
no, I'm
the
talking
money.
about where does the ad valorem tax money go? Who benefits from these property leaseholders with owning condos?
The county gets the rental income, and the school board gets the intangibles tax.
And who would get the ad valorem taxes?
Well, it'd be split as ad valorem taxes are split otherwise, Your Honor. now recognize.
But again, you're saying that you believe that if we strictly construe this statute, we would have to conclude that the legislature did not intend, if there's less than a 100-year lease, no matter what the benefits of the leasehold was, to have to pay ad valorem taxes.
Your Honor,
and that would be the easiest way, from your point of view, for us to resolve it.
Your Honor, and we respectfully submit that that's the correct way to look at the statute and to look at legislative authority. Now, if you're troubled at all by the issue of whether or not there's contribution to the public benefit, think of all the ways that the county has to get assessments.
But let me go back to the legislature. So could the legislature alternatively have taken a lease that's less than 100 years where all of the other benefits are set forth in the first district's opinion and intend constitutionally for it to be taxed as ad valorem taxes?
Your Honor, not only could it do it, but that's exactly what the legislature did in the 1971
Okay, so
Act.
you say, again, so really the way to resolve this, if it's clear, then it's really up to the legislature to going forward to resolve this.
But that's our position, Your Honor.
Well, let me ask you about what the legislature's done. And admittedly, this is a very complex thing because you've got statutes and their interaction, and as you go through it, it's kind of easy to get lost in the thicket. But it seems to me that an important part of the analysis here comes back to the language in the 2005 statute, where that has the definition of intangible personal property, and things that are going to be taxed in that manner as opposed to ad valorem, subjected to ad valorem taxes. And there in subsection, this is in 199.023, subsection 1D, there's a reference to all leasehold or other possessory interest in real property. Now, it seems like to me that doesn't include equitable ownership interest in real property. And so that's where I don't know that your statutory argument really works, because the legislature had said, had included a reference to equitable ownership. That would be a different matter. But and the other point that I would just point out and get you to respond is that we know that in Florida law, the concept of equitable ownership is an important concept in this context, because in our case, the Leon County Educational Facilities Authority case, back from this court in 1997, we said the concept of equitable ownership in ad valorem taxation has long been a part of Florida law. So that's part of the backdrop of what we have to understand the legislature is operating on. And given that, I'm having trouble understanding how an interest that could be determined to be a equitable ownership interest is going to be pulled over into the treatment of the intangible property category, a treatment that you're seeking.
Your Honor, there are two questions. First of all, as to the Leon County Educational Facilities Act, remember that the court found that was a financing arrangement. And so...
well, I'm not really relying on the holding there. I'm relying on this general principle about equitable ownership being part of the...
Good. So, Your Honor, in answer to that, let me put forward two propositions. One, the statute itself. The statute you're reading from, I believe, says such leasehold or other interest shall be taxed only as intangible personal property.
No, actually, the statute I'm reading from, the statute you're reading from refers back to the if I've got this straight, refers back to the 2005 statute that I'm referring to, and it refers to all leasehold or other possessory interest in real property, which I think is a category that's distinct from the category of equitable ownership.
Your Honor, how do we read possessory?
Well, that's what the first DCA has. That's the way they've analyzed it. Am I correct?
I think that's right, Your Honor. Your Honor, the first DCA clearly went to this benefits and burdens analysis. In the Ward versus Brown decision, of course, author is sitting on the court, so I'll not try to say what motivated the court, but it clearly places a great deal of emphasis on the fact that these leases being reviewed in Ward versus Brown were perpetual leases. That seems to be the heart of Ward versus Brown. We then move to this idea of benefits and burdens. I hope you'll look at that test of benefits and burdens very closely, because what are the benefits? The benefits that are asserted in the.
Well, it sounds like to me the benefits are that they occupy these things and essentially treat them like their own property.
Your Honor,
am I missing something here? I think if you rode up on the street and looked at it and watched it over a period of years, it would look like, for all practical purposes, they owned the property. Am I wrong?
Your Honor, you're right, because that's exactly what happens with every lease. If you look at a property, you can ride by the property and look at leased property. Who's in possession?
Well, what I'm saying,
if
you did it here for 200 years, that's what you'd see.
Well, Your Honor, that's an issue about where to draw the line on duration. The legislature decided to draw the line at 99 years. So 100 years, you lose. If it's less than 100 years and you pay rent, because when you drive by, you don't see whether or not the person who's occupying is actually paying rent. You don't pay rent if you're an owner.
Mr. Dallenberg, but that's the point being, if someone's a lessee, where people lease condos for this winter all the time, you may have a year, you might have 2 years, you might have 5 years, but the people, as I understand it, that have the possession of these condo units, they can freely sell the condo unit to whoever they want, correct?
Just like any other lessee, Your Honor. You can sell your leasehold interest. This is not a distinction that is peculiar to this case. You can encumber, you can mortgage your leasehold interest.
But I guess still the problem I'm having is how a condo unit is intangible property. It's a residence.
Your Honor, if you had a condo unit and you owned it and you had the ability to sell it, that'd be a different thing.
How is for the next 90 years? How is it different for these people than anyone else that owns a condo? What can't they do that anyone else that owns the condo unit do?
Your Honor, let me make 2 points. What can they do, and what are they required to do that no owner would ever be required to do? First of all, a lease of this county land in Santa Rosa or Escambia requires construction, requires you to do improvements. If I'm an owner of land, I don't have to improve the land. I can make a decision myself whether to improve the land. If I'm an owner, I don't have to insure the land. If I'm an owner, consistent with local ordinances, I don't have to maintain. Here, the person who leases has to improve. And why do they have to improve? It's because that is what government was bargaining for. They wanted to take this sandbar and turn it into an engine of economic development in Escambia and Santa Rosa County.
And exempt them all from ad valorem taxes.
And Your Honor, originally no ad valorem taxes on the property. Legislature in 1971 said that there will be ad valorem taxes on the leaseholds. That legislative determination was upheld in a series of cases. And then the 1980 legislature decided that the proper way to tax leaseholds of government land, because they're only leaseholds, and you don't have all the rights of an owner, and you have requirements placed on you.
But let me ask you, it seems like your argument, you're just arguing that there is no such thing as equitable ownership.
Your Honor,
and are you arguing that?
No, Your Honor. Look.
Well, why aren't at least some of these equitable ownership interests?
But Your Honor, because if you go down this analysis about benefits and burdens, it doesn't get you there. What are the benefits again? The benefits sort of occupy the property, to be able to encumber the property, to be able to sublease the property.
What more could they ask for? What benefits are they lacking? I mean, what real practical benefits are they lacking with respect to these properties?
Your Honor, they lack the benefit of being able to transfer it in fee simple. They lack
but wait. That's an argument that there is no such thing as equitable ownership, because that would apply to any situation. You'd never have an equitable owner who could transfer fee simple, would you?
No, Your Honor, in fact, most of the equitable ownership cases arise in circumstance where the person who's found to be an equitable owner actually does get title. It's a contract for deed. That's the classical instance of equitable ownership in Florida. And here, the sole issue, in my judgment, is whether the legislature has the authority to make a determination about how to tax government-owned property that's leased to private interests. Now, let's deal with the issue about private interests. Briefs for respondents seem to indicate that occupying this property by private interest is somehow evil. There's nothing wrong with that. We've been encouraging economic development since the Homestead Act 150 years ago. But we know that if we want to develop property, we want to encourage development. We know that private investment can turn property that is not productive into something that's very productive. And that's exactly what happened here. The public officials in Escambia and Santa Rosa County got what they bargained for.
Let me ask you a practical question.
If I could, his time's expired. We have another case coming up.
Okay.
Would it be okay to ask that question in the next case, or you want to have it done here? Here? Okay, go ahead.
What is the real practical effect here? What is the difference, or does the record show, what is the difference between what one of these people would pay in ad valorem tax and what they would pay in intangible personal property tax?
Your Honor, I don't remember the exact millage rate that would be paid in ad valorem tax. The millage rate here, obviously, is 2 mills. But let me make this point, if I may, Your Honor. This is not the only way that local government has to get money for benefits on the property. Both Santa Rosa County and Escambia County have benefit districts that are established for purposes of collecting money to pay for improvements or benefits to the property. And so special assessments and other methods are available to the counties, quite apart from ad valorem taxation. Thank you, Your Honor.
May it please the Court. My name is Tom Finley. I represent the property appraiser Greg Brown of Santa Rosa County and also the tax collector Stan Nichols of Santa Rosa County. Seated with me at council table is Rob Telfer and Roy Andrews, co-counsel. Elliot Messer could not make it. He has been ill lately. Your Honor, with respect to the question of what's the difference is very substantial because the way the ad valorem tax system works, there can be different millages assessed by each local unit of local government. So you may have a city, in some cases a county, school board, definitely, water management district, etc. So it can be as much as 28 mills in some of these areas, whereas the state intangibles tax is 2 mills.
But Mr. Finley, we can't decide the case on that
of course.
Factor. I mean, we're really, do you agree? I mean, we're really talking about a admitted facts, federal government, local government, and then the relationship under the lease. Is that the structure we're talking about, correct?
That's correct.
And then the determination comes down as to how are we going to define under Florida law, or is there any need to define that lease, what that means?
Right.
And isn't that what we're here to try to do today?
I think that there are 2 issues. The certified question before the court is whether the concept of equitable ownership applies in this context under 196,
well, but
199.
that again recognizes the statute says what it says.
Right.
And so it wants to know whether there's some exceptions to this.
Well, equitable ownership is something that applies to all of the exemption statutes. The concept of equitable ownership, for example, in the Leon County Educational Facilities Authority's case, dealt with both the educational exemption and 196.199, which is the statute cited in the certified question here. So we know from the Bancroft case before the Florida Supreme Court and the LaCifa, that's Leon County acronym for the Educational Facilities Authority, they recognized that equitable ownership was long established in Florida law. And that has to be the first thing that you look at. In fact, the LaCifa court held we're not bound and tied by the literal terms of the statute. We have to look through that to fact and substance. And so you have several
the fact
cases.
and substance of the possessory interest.
The possessory interest, or what I would call the equitable ownership.
Okay.
Right,
well, I mean, the right
that's-
to be there. That's what you're looking through to analyze on what basis does this family occupy or possess this property
Or own. And I would point out that part of the statute that they keep omitting under 196.199(2)(b is the last sentence that says nothing in this exemption shall be deemed to exempt improvements, buildings, etc., that are owned by the lessee. Owned meaning, it has to mean equitable ownership.
Well, what is it? Here is my problem about this statute. It's clear that in 100 years or more, the legislature clearly intended for this to be, those interests to be taxed based on ad valorem taxes as ownership. The issue of 99 and less is left to some vague idea of how we're going to help construe the statute. Why shouldn't the legislature have an obligation in a situation that if they intend for there to be, for these types of leases, equitable ownership, to set forth what the factors should be to consider, rather than us trying to decide, well, if this one's renewed for in perpetuity, then it's, yes, if it's, and there are different renewal options here. It seems to me that that's an awfully inaccurate way to assess something that should be precise. So what's the answer to that? I mean, shouldn't the legislature solve this?
I don't know if the legislature can solve this. They've tried to do it several times, and contrary to what they've argued in their brief, the legislature, this court on 2 occasions has struck what they've attempted to do to what this court called manipulate the criteria, manipulate the statutory criteria. I think we have to look at substance over form. You're never going to be able to, as a legislature, pin down every attempt to elevate form over substance.
Except that they designated a year, 100 years or more, and were precise about that, correct?
Three courts have addressed that. Parker v. Hertz, Hialeah, and Ward v. Brown addressed that 100-year statute. And what they all said, and what I believe is correct, is that sets a bright line for any lease that's over 100 years. But it doesn't set the criteria for what is owned under Florida law for other categories of leases, including 99-year leases with renewals for 99, with options to renew for 99 more, or ones that are tied to the Escambia Santa Rosa lease, which automatically renews.
But there are different, there are different leases. What if there was no renewal? Well, it was 99-year absolute lease with no option to renew after 99 years. Would that be enough to be taxed during the duration of the 99-year lease as ad valorem taxes?
Yes, it would be. And in my judgment, depending on all the facts and circumstances.
The option to renew is not a critical factor?
The option to renew is important. It's one of the bundle of sticks. That goes on in real estate litigation all the time. The courts have talked about the bundle of sticks. And you can't really isolate on any one stick. You need to look at them as a bundle. That can be a factor, whether it's been sold as a condominium, whether the county, as is in the majority of cases in this case, the county entered into the declaration of condominium. By law, that means they submitted their interest to the condominium form of ownership, which the legislature has determined is a real property interest.
Does it matter whether the tax is on the land and the improvements or just the improvements? In other words, I could see a better argument being that the actual condo unit that is possessed can be taxed, but why should the land? where is it that sometimes the land is taxed and other places the land isn't taxed?
Well, I think the land is subject to the same type of equitable ownership argument as the improvements are. And
So
I think
what was the distinction made in those situations where the land was taxed and those where the land wasn't taxed?
The way that both appraisers are doing it now, Santa Rosa and Escambia, is to assess the improvements, condominium units, and land. Mr. Jones in Escambia County.
When you say now,
now,
you mean in these cases?
No, sir.
It's different in these cases.
Correct. The Santa Rosa property appraiser started this litigation in 2001, and he was successful. The Escambia County property appraiser saw no difference and added his to the tax rolls in 2004. Mr. Brown in Santa Rosa County then thought, based partially on the dissent of Justice Benton or Judge Benton in the first DCA Ward v. Brown case, said where he said there's no distinction between land and buildings here. Mr. Brown then put the land on. So it has a long history of slight variations. But as of the Accardo first DCA decision, Escambia County now has the land and buildings on the tax rolls. I would like to say something about the questions about legislative discretion. And yes, the legislature has powers of classification, but this court held in the Sebring decision that the legislature's authority is not unbridled, and it has to be measured with the yardstick of the Constitution. As I mentioned just a second ago, there have been 2 occasions where this court has struck efforts on Santa Rosa Island to manipulate the structure in order to gain an indirect exemption, which is what they're again doing. Williams versus Jones, also from this court, said, and this is a quote that gets chopped short in their briefing, it says, the legislature has the power to classify, and then this is the part that they leave out, so that all property devoted to private use is treated on a parity, and therefore there is an equitable distribution of the tax burden. Basically, the appellants contend for a constitutional exemption. There's no authority for this treatment in the Constitution, which is fatal to their case. And what they were seeking in the Williams versus Jones case was intangibles tax treatment, just what we're talking about here. And
isn't this different because of the reverter clauses? That if this is sold, isn't there a reverter that becomes operative?
These are the same leases.
Excuse me?
These are the same leases.
No, I'm saying that if you have an actual sale, if we try to treat this property as all other properties, aren't there reverter clauses provisions that prohibit the sale?
There were in the Williams versus Jones.
I'm asking this case just right now.
Yes.
Are there not? This property originally was owned by the federal government, correct?
Correct.
And it's the federal government reverter clauses that we're talking about, aren't we?
Well, the federal government gave it to Escambia County.
Well, I understand, but certain restrictions, though, also.
To hold bare legal title.
But prohibited the sale of that land, did it not?
Prohibited the conveyance of bare legal title is how I would view it.
Well, see, here again, I think this gets into a game of semantics rather than solving the problem, Mr. Finley, is that, as I look at this, there's got to be a practical way to approach this. Mm-hmm. And it was very clear to me that the federal government still holds the trump card, that if you want to call all this ownership, then when does the reverter come into play?
What this court held in Lasifa was that the presence of bare legal title was not significant to the outcome. In fact, the Supreme Court in Lasifa reversed the First District Court of Appeal and said, you're only looking at legal title. This has to be an analysis of equitable ownership. So that preservation of the legal title in Escambia County to this court would have been not significant in the Lasifa case. Can I give you a clear answer? No, but I can tell you that the intangibles tax treatment is not something that is authorized by the Florida Constitution.
Well, no, I understand that. It comes straight from the statute. But the concept of the prohibition of the transfer of title to property you own is also not a concept that's of constitutional basis either, is it?
I'm not sure I understand that.
Well, is question. That our transfer of real property is protected by the Constitution, and under these circumstances, if there are reverter clauses that prohibit the transfer of ownership, it seems to me that the whole concept is extra constitutional. It's beyond the realm of the Constitution we're talking about.
I would respectfully disagree with that, Your Honor, because there is no prohibition on conveying equitable ownership in that law. The United States government, Escambia County, no government entity is involved in this case in complaining that too much was conveyed. I think everyone would concede that what was conveyed was lawful. The question for the court is, what was conveyed, is that equitable ownership under Florida law? And I would submit that it is, using the standards of LaCifa and all the other.
Well, then it's not consistent then with the reverter on the transfer of the property.
I think it's just as consistent with the reverter as the Bancroft case was, where the United States government had legal title and the equitable owner was the private party. And I think there are other cases where that exists, where the county was the
and the private
involved.
The equitable owner there was subjected to taxation,
Correct.
even though the federal government had the legal title to the property.
Correct, and that's the Bancroft decision, yes.
But this is not dependent upon who's taxed. This is dependent upon ownership, isn't it?
That's the same as in Bancroft then. The private party that was the equitable owner was the one that should be assessed full tax.
I just said no, it doesn't depend on taxation. It depends upon who owns it.
Who is the equitable owner of the interest?
Well, you keep restating it, so I guess you're right.
That's how this court has defined ownership. They've defined ownership consistently as equitable ownership. In LaCifa, the party that had legal title was determined not to be the owner for ad valorem tax purposes. And this isn't something that the courts below made up, as they suggested. This is something that has been a long time part of Florida law, as Justice Kennedy pointed out.
You were talking about the bundle of rights or the sticks that would make up equitable ownership, and in answer to my question, you said that the fact that there was renewable lease options was not determinative. So yet Mr. Dallenberg said, well, they've got burdens that ordinary property owners wouldn't have. Could you say that if you were to write this opinion out of the court, what would you say were the most significant benefits that the plaintiffs, the petitioners, have enjoyed and continue to enjoy?
I would follow this court's 4 decisions on Santa Rosa Island that conclude that these interests are tantamount to ownership and the equivalent of fee simple ownership, and I would follow the district courts of appeal decisions, 3 of them that are published, that say, including from this case, that say the properties are used for purely private purposes. The private party gets all of the rights to capital appreciation, all of the rights to rental income. They have the right to convey.
On capital appreciation, that means that if they, whatever it's appraised at when they go to sell, they would report that as capital gains?
Capital gain. I don't know if the tax treatment would.
Can they have homestead on these properties?
Yes.
They get a homestead exemption.
Our position is that they're granted homestead. They've applied for homestead and it's been granted.
Okay, so capital appreciation, but you don't think, and I'm concerned about this, that whether they have what the renewal term is a significant part of the bundle that we should be analyzing?
I think it's significant. I think if you have a 99, the most common lease in this case is a 99-year lease with an option, clear option to renew for 99 years, with an option for further renewals on like terms.
And that's every lease that we have in front of us?
No, there are some slight differences, but I would say this. In this case, there were two petitioners, Mr. Lewis Ward and Mr. Robert Coley, that were considered to be class representatives of a class of taxpayers in 2002 through 2005. And so they argued that these represent everybody. And those were 99 plus 99 plus options to renew after that, and there were condominiums.
Has opposing counsel ever made an argument that would split these up some way and say that, well, even if some are involve an equitable ownership interest that's subject to the ad valorem taxation, these others don't for these reasons?
I would submit that they've only done that in their briefing before this court, because what they did in their original complaint was to attach if I go back to 2002 to 2005, they had class representatives that
But
were
we
99%.
can't. But this lawsuit isn't a class action.
No, it isn't.
So what did they allege in their complaint in this case?
I'm sorry, there were 6 leases that were attached to this complaint, and the 6 leases were alleged to be common to all of the other leases. And so those are the ones we focused on, and the ones that we described in our facts. Those were all 99 plus 99. The first DCA, in hearing the arguments before it in the Areola case, said they're not arguing that there are distinctions among these leases. They're arguing that they all fall in the same boat. This court, in Williams versus Jones, consolidated a number of cases of all the leaseholders on Santa Rosa Island, and they dropped a footnote that said one of these leases is only for 25 years. But the question really is, who has the benefits and burdens of ownership on January 1st? And I would suggest to you that what Williams versus Jones also did was to state that 100-year statute or the 99-year statute in those days was a standard for valuation. And so perhaps that as you get closer to the lease term, there could be adjustments to value. That remains to be seen. But at this point in time, you have a situation where 6 trial courts and 6 appellate courts have looked at this. They've looked at their sales contracts by which they sell these condominiums. There are condominium declarations whereby the county submits its ownership interest to the condominium form of real property ownership. All of these records, they've done all this labor, and every one of them has determined that these Santa Rosa Island petitioners are the equitable owners of the properties.
Are they appraised at a lesser amount than if the same exact condo? Well, let me finish. It was a quote normal condominium where there's not a question that where there's a portion of ownership of the common elements, the developer has transferred it. Do they get the benefit of a lesser value because of the unique structure of this being leased by the county?
No, and the reason is that the sales price generates the value.
So the sales price, it's exactly the same sales price whether this was owned by the county or not?
We didn't have appraisers come in and compare Okaloosa County, for example, with Santa Rosa County.
But they could make that argument if they wanted. They could say
Sure.
You've over-appraised because you shouldn't appraise this as high as
Right.
a identical situation where it's not owned by, where the land is not owned by the county.
Correct. They did not raise any valuation challenge in any of these cases.
Thank you for your argument.
Thank you.
Let's move now to the next case of 1108 Areola versus Jones. Because of the same issues in the case, we encourage you not to use the full time if you don't feel like you have to. So you may proceed. You are 2 minutes over. So let's proceed in this case. But you've got 20 minutes to address any of the issues that you want to talk about.
May it please the court, my name is Danny Kepner, along with Mr. DeAllenbert. We represent, in this case, leaseholders at the other end of Santa Rosa Island, called Pensacola Beach. And it's within Escambia County rather than Santa Rosa County. The District Court of Appeal in this case certified this question of great public importance. That is, whether these lessees are equitable owners when they do not have perpetual leasehold and they do not have a right to purchase the property for a nominal sum at the end of the lease term. And the statute clearly says...
Helping me understand
Yes,
the question and the facts here, could you tell me what the lease renewal terms are? Relevant lease.
Pensacola Beach, none of them have the provisions that were found.
What are they? Don't tell me what they're not.
Sure.
Please tell me what they are.
Well, they are varied. Some have no provision whatsoever for renewal. There are about 600 leases in our case, which is we've got 2,200 parcels, and about 600 of them have no provision for renewal whatsoever. So at the end of the lease term, they're going to have to talk to the county and see if they can get a deal.
And they have are those 99-year leases?
Yes, they are, Your Honor.
Okay.
Many of them have a provision that says you can renew this within, if If you do it before 6 months or nearly up, on like terms and conditions. Now, it does not say same rent. It doesn't say that. And courts have said many times, if it just says like terms and conditions, it's not a guarantee at all that what rate you're going to get. You've got to strike a new deal with the county. That's the 99-year thing that he keeps saying is like an automatic renewal. No, not automatic. Not in any way whatsoever. The leases on Santa Rosa County had a provision, many of them, that said this is automatic renewal. These don't have anything like that. Instead, you have to go to the county and say, I'm near the 99-year end of this. I would like to renew. The county then says, well, like terms and conditions is you're going to have to pay rent just like you did before. It's just going to be a higher rate.
Well, I don't understand why the rent is not a term. The specific rent. I don't understand that.
Well, because it doesn't say identical. It says like terms and conditions.
Oh, but that's the same. Like means the same, doesn't it?
Well, a like term would mean
well,
you got to pay.
Going to be your client's position that they're entitled to keep that going the way it is now?
I'm sorry, Your Honor, I didn't understand.
Wouldn't it be your client's position, though, that they would be entitled to keep the same rent?
Well, that would be an argument to make to the county, yes, sir. But that hasn't we haven't gotten to that date with these leases. The first one started, I think, in the late 50s, and so they're not yet at the point where those renewals have happened. I do know that when people want to do something slightly different with their property, the county says, okay, well, let's strike a different deal on your lease term, and that being the rent. So there's nothing automatic whatsoever here. You've got a 99-year lease. Now, I do want to address this whole question of what the legislature was doing. In 71, they passed a statute that did cause every one of these leaseholds to be taxed, improvements and land, as if the lessees owned it. In 1980, they changed their approach to it. And they said, we're not going to do that anymore. Instead, we're going to say, these properties are going to be taxed only as intangible personal property, except for the improvements. If you own the improvements, then you get levied with ad valorem tax. On Pensacola Beach, the cases before you only include the taxation of the improvements. The subsequent cases we've had to file are not part of this case before you today.
Do you have a different position as to what kind of tax should be levied on these properties in this case? I mean, I understand Mr. Dallenberg's argument in the other case was that only intangible personal property tax is applicable. Is that your argument in this case, too?
It is, Your Honor. It is. That's what the statute says. It's going to be taxed as intangible. It says improvements, it's the same statutes. We're talking about exactly the same statutes. But it says the improvements, because that's all we're dealing with here, can be taxed if you own them. So we get into this question of, well, who owns these improvements? Well, first we look at the leases. The leases all say the moment they're placed on the property, a permanent improvement, forthwith is titled in Escambia County. Forthwith. It was different in the Ward versus Brown case. There it said, for Santa Rosa County, that the county was going to get the leasehold improvements at the end of the lease term.
When you're saying the improvements, we're talking about the condos themselves, correct?
The building, yes.
And so
any kind of
you're
improvements.
saying that the leases in this case say that those buildings belong to the county?
Yes, I am, Your Honor. That's correct, because that's what they say, every one of them. Not one of them says anything different from that.
Well,
so
why wouldn't that just be fair legal title as opposed to, because the difference in practical terms between that and the other is non-existent, because they get the same use of the leaseholder gets the same use of the property. They've got the same practical rights with respect to the property. There's just the difference in the issue of who has the bare legal title.
Well, I would disagree with you, Your Honor, because let's say I'm Donald Trump and I got a nice place on Pensacola Beach. I decided I'd like to have that building across the bay and move it to Gulf Breeze. Couldn't do that. I'm a leaseholder. I can't move that property. I can't move the improvements. They must stay in place. I must improve them. I must keep repairing them if they get torn down. So it's different. We're a leasehold. It's not ownership.
But you still have the right to rent it?
Yes.
And collect the rents.
Just
you
like,
have the right to change it and make improvements, correct?
Yes.
You have the right to encumber it.
That's correct. Just like any lessee.
Okay.
Just like any lessee. And we've shown you the case law in Florida.
You can transfer your interest?
I'm sorry?
You can transfer your interest in that property?
The leasehold interest? Mm-hmm. Yes. And if it appreciated in time, then yes, you get the appreciation. That is the difference in price, because it is a leasehold. And a leasehold.
But are those the factors also that you take into consideration when you're talking about whether or not someone is an equitable owner?
I'm glad you asked that question. Because if you have an equitable ownership with a leasehold, here's real quickly what you have is you have a title holder who will not keep the title, and you have a lessee who will wind up with the title. That's not what we have here. What we have here is a lessee, the title holder, Escambia County, who will never lose the title. Escambia County always keeps the title. And you have a lessee who will never have the title. Our clients will never have the title. They don't have any contract deal. Now, this court has stated in the very case...
You're arguing the same case I lost as a lawyer here in the Leon County Educational Facilities versus Hartsville.
That's where I was going.
I mean, you're making the same argument I made to this court way back when, and I lost.
Actually, the difference here, Your Honor, is that transaction was a financing arrangement whereby that facility was going to be owned by the government when all the payments were made. There was an option to purchase at the end of that for $1. There's no option to purchase here at any price. And there's never going to be a transfer of the ownership, the actual title to the property, the improvements, or the land to our clients. So it is different. And that distinction...
So you're saying that there can never be equitable ownership unless there is the prospect for legal title to ultimately vest in the current equitable owner.
That's
now,
what I'm saying.
What case supports that proposition?
Well, that case supports that proposition.
I read it, and I just read it this morning, and I don't remember that being in there.
Well, here's the language and it was not underlined in the opinion of the First District
Well, I've got
Court of
it.
Appeal.
So tell me where it is.
Well, it's in between the lines that are underlined. The sentence says that, and it cites the Gautier versus Lepoff case.
We're talking about Leon County Educational Facilities? No?
Well, it is in that case, Your Honor, but that's repeated in the Areola case. The court said, and they cited Gautier versus Lepoff in the Leon County case. They talked about you don't, just because you have an option to purchase doesn't mean you're an owner. And then it says, we have said that if you have a leasehold, even if you have an option to purchase at the end, you do not have an equitable interest in that property. You do not. If you have an ordinary lease. Now, I say the Leon County...
That's not the point. That's not the precise point you've made. That's a different... I mean, you're extrapolating from what's here. What am I missing?
Well, I'm not extrapolating about what the facts were in the Leon County case. The Leon County case said this is a financing deal, and we don't have a financing deal here.
But they don't say that this is the only circumstance under which there's no holding here that that's the only circumstance in which there could be an equitable ownership.
Well,
do they?
By saying if you have an ordinary lease, you have no equitable ownership, then aren't they saying you got to have some sort of extraordinary lease? And that's my point.
Well, an extraordinary lease might be a lease that's perpetually renewable, or renewable virtually perpetually. I don't know, but that seems to be different.
And that's where I was going with my argument, Your Honor.
Okay.
And that is...
I'm glad I helped you there.
Thank you very much. Because it takes you to this question: are these extraordinary leases? They're not. They're ordinary leases. Whereas in Ward versus Brown, what was before the First District Court of Appeal was in fact extraordinary leases, because they had this lease term that said we're going to renew automatically. And it also said something different from our leases, that the ownership, the title to the improvements were not going to go to the county until the end of the lease term. And the First District said, well, if it's a perpetual lease, there is no end of the lease term. Therefore, the lessee always has the ownership of the improvements. They don't have title, they don't have bare title, but they always have ownership of the improvements, and therefore they should be taxed because they own the improvements. That's an extraordinary lease. Now, what's another extraordinary lease? I say the other extraordinary lease is the lease in which there is this striking a deal where we're buying the property. The lessee is purchasing the property. It's like a contract for deed. And Mr.
Well, it's really not whether it's extraordinary. It's really you have to look to whether under the terms of the transaction that you're looking at, you have the rights and obligations that would constitute indicia of ownership, right? Not whether it's extraordinary or not. I mean, we could look at whether these really are kind of extraordinary circumstances. It's probably not everywhere in the state of Florida we have this exact scenario where we have land owned by the government and the lease deals that we have of 99-year, sometimes perpetual leases, and those kind of circumstances. 99-year renewable leases for residents aren't walking around everywhere. So they are somewhat extraordinary. But beyond that, what we look to in Florida law is whether or not the terms have indicia of ownership.
Well, the question for this court really is, do you hand that responsibility over to the property appraisers? They just walk around and say, well, I think you've got equitable ownership. I don't have any guidelines. There's nothing precise about what that is. The statute says there's a guideline that tells you.
That's just part of Florida law. I mean, this whole concept of equitable ownership is part of the structure of Florida law with respect to ad valorem taxation. Am I wrong?
You're not wrong, Your Honor, but
maybe undesirable, but we would have to undo a lot to get rid of that, wouldn't we?
But there's nothing that's ever been said by this court or any other court. Look, property appraiser, you go look at any lease you want to and figure out any lease of government property, and you figure out whether it's equitable ownership or not.
What we've said is that whether there's virtually all of the benefits and burdens of ownership. That's kind of the penultimate line there. In our case, in the Leon County Educational Facilities Authority, that seems to be what we look at equitable ownership. We're looking at whether there's virtually all the benefits and burdens. Now, again, that's not precise because different people can disagree about what virtually all would amount to. But isn't that really what we need to look at to determine whether there's equitable ownership?
But you need to look at all, because if there's not ever any opportunity for that person to be the owner, then how are you going to call that ownership?
Well, I understand.
It's still a leasehold.
It's your position. It's your position unless that there's an opportunity, a clear legal path for the owner to get, for the equitable owner to get, or the leaseholder to get legal title, then there cannot be a equitable ownership interest. I just don't see that. With all due respect, I don't see that proposition stated either stated or implicit in Leon County. I don't know if it's somewhere else. Tell me where it is.
Well, I'll follow that. In Leon County, what cases did they cite as authority? They cited Hialeah, which was a case in which ownership was going to go with the payment of like $100 at the end. It was a financing arrangement. That's the first case they cited as the authority for their position. And then they cited the first union case they approved. Same kind of transaction. The lessee was going to become the owner at the end of it. They cited Bancroft. Well, Bancroft was a contract for deed with the United States government. I pay you for 5 years and I get full ownership at the end of 5 years. During those 5 years, that lessee had to pay taxes because he was an equitable owner, just like any contract for deed. So the cases they cite, the cases that were cited by this court, all get to the same result. The only exception from that is Mycos, which was where people owned shares of stock in a corporation that owned the land, and they put their mobile homes on it. The court said, well, you've got equitable ownership of that property. It's not a leasehold. Doesn't match up anywhere to these facts.
Well, I just have trouble conceptually with the notion that if someone has a lease that is perpetually renewable on the same terms, and they have the right to keep that property just like they're the real owner of it. I have a hard time seeing why they don't have virtually all the benefits of burdens of ownership, even though there's never going to be a day when they will get legal title. Conceptually, I don't get that.
Well, again, what authorities did this court rely upon in the Leon County case?
I understand your point about that, but you've got to look at the reasoning also about the benefits and burdens of ownership. That's what's driving it all. The fact that the particular cases involve particular facts, circumstances, does not mean that exhausts the possibilities for where equitable ownership may exist.
Well, the 4th District in Robbins versus Mount Sinai did a careful review of these cases, including the Leon County case, and said this, in their opinion: if you do not have an option to purchase at the end of the lease term for a nominal amount, you do not have equitable ownership. And they ruled that in that case, there was not equitable ownership of the improvements that the person had all kinds of use of. Now, Mr. Finney's going to say, well, that wasn't real property. Well, we're talking about improvements. We're talking about things that are saleable, like improvements. Then you go to the Dade County case. It's Dade County versus the Brothers of the Good Shepherd. In that case, they had a 99-year lease. They had full use of the building, this charitable entity. They had full use of the building, but they didn't have the right to purchase it at the end. They didn't have right to get the title to the property for a nominal price at the end. 3rd District said, you don't have equitable ownership. So you look at the case law in Florida and you say, how do we measure it? You either have a perpetual lease, perpetually renewing, where the improvements never go to the owner, or you have a situation where the owner, the lessee, ultimately becomes the owner. If you don't have either one of those, then all you have is just a normal lease.
You're into your rebuttal time.
Thank you, Your Honor. I'll reserve that.
May it please the Court, in this case we represent Chris Jones, the property appraiser of Escambia County, and Janet Holly, the tax collector of Escambia County. I would just like to point out that with respect to the last point that Mr. Kepner was attempting to make, that you have to eventually get legal title in order to be an equitable owner, that's inconsistent with what they've written in their brief. At page 34 of their brief, they've talked about the category of equitable ownership where you have leases in perpetuity. They've talked about leases where there was an option to purchase, and then they say, quote, but Florida case law does not limit equitable ownership to just these two circumstances, end quote. Now, if you look at the Lasifa case, that's clear. The Micos versus Kings Gate case is not a case where those individuals were ever able to have any option to get legal title, and there was certainly nothing in perpetuity in that case. In addition, there are 11 other cases, including Service Metro, which Justice Polston authored from the first DCA, where there was equitable ownership, and the private corporation, even though Escambia County had legal title, the private corporation had all the benefits and burdens of ownership, so it was deemed to be the owner. There's the 4 cases that came from this court where the Santa Rosa Island interests, the same ones involved in this case, were determined to be tantamount to ownership or the equivalent of fee simple ownership. There's a U.S. Supreme Court case where the United States government had a 75-year lease, and the question was the taxable value or taxability of a building on that. And the U.S. Supreme Court said, well, the building's going to last 35 years. The lease is 75 years, so they're going to get the whole value in reality of that building, so therefore it's subject to state and local tax.
I thought, I heard
on
him,
and on.
I thought your opponent said that a number of the leases in this case involved 25 years?
No, I didn't say it. What the first DCA said was that the parties in this case, in Areola and the court below, quote, parties treated these leases as identical for purposes of determination of the issues in this case, end quote. Then they said, quote, looking at the benefits and burdens of ownership, these Escambia County leaseholders are no different than the Santa Rosa County leaseholders in Ward v. Brown or Accardo v. Brown.
So I assume you agree with that. And so it doesn't matter. I guess my question really was, it doesn't matter if we're talking about 25-year leases as opposed to 99-year leases that are renewable?
Well, I can tell you what the Supreme Court said when it looked at it. They said that in Williams v. Jones there was a 25-year lease. They treated them all the same, and they said they were tantamount to ownership. I would submit that there's probably a question of value in there that could arise in the future, and maybe if there's a shorter duration to the end, maybe it has less value. And the market would determine that. It's not subject to the sole discretion of the property appraiser. It's subject to the courts and the VAVs.
I mean, just as a logical sense, we start with a 1-year lease. Yeah, it's
a factor.
Okay. A 5-year lease even. I mean, if these are prime oceanfront and you've got a lease for 99 years, to me, there is a significant difference in 5 years, 10 years, and maybe even 25 years. So I wouldn't really, as long as you're dealing here with 99-year leases that have been stipulated to be the same, I really don't think we need to get into what would we do with a 25-year lease.
I would hope that's the case, and I think that what they've
I
done
would
here
suggest you hang your hat
Be
on
the
it.
case.
they've attached.
Well, the other side seems to hope that's the case too, right? I mean, the way they presented the case. Am I wrong?
All I can say is that they attached 6 leases to this complaint and said they were representative. In the Ward case,
The same.
699 plus 99, and with options to
In
renew
the
for 99.
Areola case.
Pardon?
In the Areola.
In the Areola,
case.
they did the same thing.
They have different leases, but all of them are 99-year leases.
Correct. So those are the ones that they represented to this court to be common to all. And the first DCA looked at it and said, there's no difference in the terms of these, and they're not trying to make a distinction between types of leases. And so I would submit that they all fall in the same
I thought
boat.
it was earlier when he started talking about 25-year leases.
I think the bottom line here is that you've got a period, you've got individuals, the petitioners, that go to offices of realtors, and they sit and they sign closing documents that say, I'm purchasing this condominium for $200,000, $300,000. They buy it, they walk away, they go, they live in it, they rent it, they depreciate it, they take tax deductions on it, they realize the capital appreciation. The county doesn't even have to know who they sold it to. Ms. Boldman was testified in deposition from the Santa Rosa Island Authority. They don't even keep track of who owns these condominiums. These leases are not as simple as they describe. They're typically to developers of condominiums. And the developer takes the lease, pays as little as $330 a year, and then constructs condominiums and sells those condominium units to the people. And those people that live out there can send their children to public schools. They can enjoy the benefits of the courts, the property appraiser,
Well, wait,
which
that's
I guess they don't like.
Hold it. At that point, I mean, the idea that someone can send their children to public school, someone who leases an apartment can send their. So I don't.
True.
I mean,
Well,
as you're
but
going
they-
into this mode here, I don't really think that now you're making a policy argument that I would say, and I agree with Justice Lewis, that the argument as to whether this looks and feels like an ownership is really what we're looking at, not whether they don't pay as much taxes as someone else. I mean, that's, to me, not what this case is about.
Well, I think that the Williams versus Jones case and the Sebring case do bring those principles in. And in fact, in Williams versus Jones, which dealt with Santa Rosa Island cases, that we approach it on the premise, and this goes to the appropriate deference to the legislature as well, which is one of their arguments. We approach it on the premise that this is a democracy in which every parcel of property is expected to bear its due portion of the burden of government. Courts have no more important function than to direct the current of the law in harmony with sound democratic theory. And I think that goes back to the other point that I raised about, yes, the legislature has powers to classify, but only as long as the burden is shared by all.
Do they can they then claim homestead exemption
Yes.
on this property?
Yes.
You wouldn't turn around and say, no, you don't own this,
Oh, no.
so it's not
No.
homestead.
Not at all.
Doesn't the Florida Constitution actually provide for leases exceeding 98 years for homestead exemption?
Yes, Your Honor. Thank you for pointing that out. That's in Article 7, Section 6. It's very clear that equitable ownership doesn't just arise from the case law. It's also in the Florida Constitution. And it says for homestead exemptions, if there's a leasehold more than 98 years, and that's with no renewals. So if you have a 99 with no renewals, that qualifies as equitable ownership for purposes of the homestead statute. And we think that these should be all read together. And I would just finally point out that there is an affidavit also from the budget director of Escambia County in this case that confirms that none of the lease fees that are paid go to the local schools. None of them go to the county's general fund. They're used for promotion of activities on the beach.
How much are the leases?
Well, it varies. And the first one that's attached as being common is $330 in a year. Now, I think when you get to the condominium level, there might be a master lease, and then there's individual leases that might require them to pay more than that. Are there any other questions?
Thank you for your arguments.
Thank you.
Rebuttal.
I do want to address the Service Metro case, since that's been brought up. In that case, the lessor is the one who was found to have equitable ownership, not the lessee. So it's like not comparing an apple to an apple, it's comparing an apple to an orange. And I would point out, too, that the district court didn't really describe any of these particular benefits and burdens. And it's not that benefits and burdens are necessarily not to be included in the discussion, but you've got to say to yourself, how can I say that a lessee becomes an owner just because it's a lengthy lease? And as has been pointed out, well, where's the cutoff? Well, the legislature has made that cutoff. And now he's arguing a constitutional argument. I contend they don't even have standing to be in this court to talk about that. Property appraiser doesn't have standing under the Crossings case. The tax collector doesn't have standing under that same concept of the Crossings case. They are supposed to be enforcing the law, and they're not entitled under the law, with our separation of powers, to start turning around and saying, I'm going to do something different. I don't like that law, and therefore I'm going to do something different. And that's what they're trying to do here. They're trying to say, let's change the law. Let's make it different. The legislature has made its cutoff, and it's made the determination. I totally agree that the concept of equitable ownership is part of the common law of the state of Florida in the area of taxation. But if you don't have something to peg it to, then you are simply saying it's just whatever. And I argue that what the district court did here, First District, they basically said whatever. They recited the Ward case, but the facts aren't similar to Ward because we don't have perpetual leases. The facts aren't similar to Ward because we don't have ownership in the lessees. The title is in the county the whole time. So to say that that case controls, actually the Bell versus Bryan cases control, and this court, the First District said, as the trial court said, equitable ownership was part of the Bell versus Bryan case all the way up, all the way through. That case says, no, you tax it as intangible, and it's not owned. These improvements are not owned by the lessees. Thank you very much.
Thank you for your arguments. Court is adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.